Hello, it's attorney Brian Ponder, also known as Brian the Credit Lawyer. Just want to do a quick video. The topic is how do I find credit or debt collection violations? I'm doing this video because I got a lot of questions recently about, hey, how do I find a violation as a credit repair person or as a consumer? Mostly I'm hearing this question come up with some credit repair organization owners. Well, typically what I tell credit repair organization owners is to not so much focus on violations, but more so to focus on derogatory information and how to attack it. You're not in court. You're not trying to necessarily quote statutes or identify what law is violated. We know in general, if you're dealing with a consumer reporting agency, your law of reference is the Fair Credit Reporting Act, or FCRA. If you're dealing with a debt collection agency, your applicable law is the FDCPA, Fair Debt Collection Practices Act. Beyond that, you should really not try to dig into particular parts of the statute and quoting what law is violated, et cetera, but you can feel free to put the business on notice that you understand that what they're doing is against the law, and that you want it corrected. Dispute letters should not go into any analysis of the law. I think you're potentially hurting yourself and your client by narrowing the issue beyond the statute itself at large. And so I suggest that you not look for specific violations, but do a general attack of derogatory information. Now, when I hear the question, what's the violation? I really think I think the more appropriate question is, how do I attack derogatory information? So if it's a credit reporting issue, two things you want to look for: something that's inaccurate or something that's incomplete. So if you have a mortgage that's derogatory, that doesn't have a balance reported, oh, okay, well, that's an easy one. It's incomplete. If you have a credit card that doesn't have a balance or has 3 years of payments and a few months NA, that's incomplete reporting. It violates the FCRA. Don't have to get tough. Don't have to get too deep into it. It's incomplete reporting. It should be deleted. It's against the law right there. So the attack on that, you don't have to say, oh, it's not my account. You don't have to go with that catch-all dispute. Those are typically deemed frivolous when there's a lot of history of payments, but sometimes that does apply. But I'm just going to give you an example. Incomplete reporting is a very strong basis for an FCRA violation, okay? And once you identify the inaccuracy or incomplete information, identify it. So don't just say it's incomplete or it's inaccurate. Identify what it is. I see this come up in court a lot, that consumer reporting agencies defend themselves by saying, well, they said it was inaccurate, but they didn't say what exactly was inaccurate about it. We didn't know how to correct it. So if you identify it as inaccurate, say what's inaccurate about it. If it says your client or you owe $1,001 and your client really owes only $1,000, well, that's inaccurate. So you would say, I do not owe $1,001. That's inaccurate. You don't have to say how much you do owe. If you're trying to delete it, you just want to point out the inaccuracy and tell them the remedy, deletion, okay? If it's a debt collection item, well, same thing applies from the credit reporting dispute side. If you're doing a dispute to a debt collector, if your position is that amount that they're trying to collect is inaccurate, say that the amount you're trying to collect is unlawful and that it violates the Fair Debt Collection Practices Act. That's an example. If you're dealing with a repossession, first letter can assert that they are unlawfully trying to collect a deficiency because they did not send the proper notices prior to selling the collateral, the car. The law, the UCC law, prohibits trying to collect deficiencies if you did not follow the law. Typically, I go straight into that. You may decide to ask for that information. What I like to do is go ahead and take a position. Say they didn't send it. And if you want to give them an opportunity to rebut that, which they may, you can even say in your letter, you know, if I am remiss and you contend that you did send me the information, well, send me all the notices that you sent and proof that they were sent. And while you're at it, include every contract that substantiate this debt, okay? And also send a calculation of deficiency. Well, a letter of calculation of the deficiency amount. So all of that could be in that one letter, but take a position. Do not just send disputes that ask for information. Go ahead and take a position. And if you want to give them an opportunity to provide information, if they're going to choose the contest route, tell them what that needs to be exactly, or else. Meaning, I want you to do this, but if you want to fight me, this is what I need from you to evaluate, you know, your choice to fight me. All right, so there you have it. That's that for now. In addition to identifying these things, once you get your results back, if something is not deleted, I recommend you turn it over to a lawyer to evaluate whether there's a violation and whether litigation is appropriate at that time. Like, comment, subscribe, share this video, and let me know what else you want to talk about.